Yes. May I have your lordship?
My lord, may be permitted to mention a matter for inclusion in the daily list, my lord. My lord, judgment was passed on 20th-06-2023, and since then I was in custody. My lord,
Or may I have your lordship? Well, this is the application.
Application for what?
Well, application for well, to permission to leave the India. But yes.
So may I be permitted to mention one matter. This is in connection with bail in connection with appeal.
Lordship may be permitted to mention one matter. Lordship, this is a Ponzi matter. We'll list it in the other bench. All right.
Your lordship, there is another matter. This is criminal appeal for inclusion in the list.
Lordship, this is for correction, my lordship.
Your lordship, one bail application. Urgent determination.
My lord, kindly to mention a matter, under Contempts of Courts Act, for listing. I had mentioned it on 19th, my lord, had allowed.
Friday.
I'm deeply obliged, my lord.
Come up on Friday. Bail, you mentioned bail application.
Bail application.
Why?
Urgent determination, your lordship.
We don't have the determination.
Your lordship, just now I received.
Oh. What is it not? One day, why mention?
Your lordship, other accused persons, your lordship granted bail.
All right, their lordships will come tomorrow.
Your lordship, 22nd is the next date. The CD will not return and the trial will get started. Your lordship, parity matter, your lordship. One small matter.
All right, 2 p.m.
To be
Similar matter, lordship. Bail application.
One day, no.
Lordship.
What is the why today? The astrologer told you better day. Wait for a day. The lordship will sit tomorrow. What is your case?
Lordship, in this case, lordship, that I am instruction from my senior that one co-accused was released, and from the NDPS Act, lordship, and
all right, give it 2 p.m. We'll take it.
grateful, your lordship.
Lord. Hey. Whatever bail application, please give notice to the state. They will they'll take out a list. At 2 p.m. we will take up the matters. Please give notice. Inform the state. All right, we'll see with the POX. Let us see. Let us see if bails are on parity, we will consider. If not, if we'll have to apply mine independently, we are not going to consider. Sir. Yes, Mr.
Lord, can I pray to Justice Bakshi? If your lordship takes up those appeal prior to your lordship's pre-Telangana days as item number 1 and 2. I'm told your lordship has told while hearing the bail in connection with appeal. Sometimes it is good that your lordship is hearing up the appeal.
Correct.
But if it is posted as to be mentioned next day, your lordship loves to take up appeals.
No, we will definitely do it. The thing is that if it is heard out and we can finish it off on that day, to keep it, we are loath to hear the matter twice. If we hear a suspension of sentence, if we see the suspension,
instead of Thursday, make it on Friday. Thursday, your lordship decides to hear the appeal on Friday. On the next day only.
all right, that will accommodate. The thing is suspension of sentence. Someone is in custody for 2 years, 3 years, hearing the suspension once and then again hearing main matter, it doesn't make sense.
Sarjati Doctor had briefed me as a senior. It was a Monday morning, item number 1, under to be mentioned. I'm telling the staff.
No, we'll do it. That
my hearing was limited to perhaps, my lord, 2 minutes.
So that will be limited because your hearing's already done on the last day, na?
Because Justice Bagchi has read the brief.
So the question is, me reading the brief is not the end all. You have to assist me because I may commit a mistake.
Assistance.
I may commit a mistake. I'm telling you, yesterday what happened was, I tell you, Mr. Nominal Day and Mohapatra was appearing. SCST Act, right? I was under the impression of the old pre-amended SCST Act that intention must be there, that the person is a member of the caste for committing the crime. You remember Justice Patel's judgment in the Supreme Court judgment. Then Mr. Des Jr. showed me the amendment where it says knowledge as to membership is good enough. So we immediately changed. So the purpose of hearing, sir, is that so that multiple minds get together to solve a problem. Otherwise, so we can do it in vacuum.
I'm telling you, Lordship, I had a heap of paper books, which have.
Please, what I am saying is, what is happening is
I
your
didn't have the setup. I
your
don't know
suspension.
the appeal.
But we have given this room also.
Your Lord,
Why
he
don't
has a blank check.
why don't you, Mr.
He
Rai?
has a blank check.
I'm telling you, you have
2 vacations have gone.
no,
He
you
has
you have
not
PCs.
looked at the software.
You have PCs in the you have your computers, right? So why don't you have a database of cases
Exactly,
which are
that is what
allotted?
I'm telling you,
So-
Lordship. I'm
One holiday is good enough. So every day, as soon as allotments are made, on the next day it should.
No, the new thing, what has happened is, the Chief Justice had visited Patna perhaps. And there is a system in the Patna, as well as perhaps your Lordship has seen it in Telangana. In Gujarat, it is also there, court case management system. Since the inception of the FIR till the SLP, a man clicks on that PS case number.
Correct.
Every order, everything is uploaded, everything is there. That system we are trying to. I had a talk with Justice.
Not only this is a part of the ICJ's interoperable criminal justice system. The seamless exchange of data between police station, court, forensic laboratories, hospitals,
This High Court is also trying to
and
adopt
the
that.
correctional homes. These are the 5 pillars. The data between the 5 pillars must have a seamless movement.
This thing, what I have
Your
seen,
police stations have not migrated into the ICJS till now.
police doesn't have any information, any clue about the revisional applications and the appeals being heard.
That
They
is
don't have any clue. We don't give them, pass on any information.
not correct. What we will do is we have made it clear. Whoever is there in the suspension, please
You can also
request.
fix it
No,
about
please.
next
What we say is, whenever a lawyer is assigned a suspension, let him find out from the PP office.
I'm telling you, Prasad, what had happened is I had found a heap of paper. Those I have allotted during the vacation. From
Very
my
good.
house. I didn't have the database also.
No, that is all.
So there might be some.
All fine, but a lawyer who is assigned a application for suspension should make his own endeavor to find out from the public prosecutor's office who is in the main matter, so that both of them can combine together. Our purpose is not to eliminate lawyer A or lawyer B. The thing is that more the merrier, let both of them address us, or whoever is present address us.
एक का फिर नहीं मिलता है जैसा बोल रहे थे.
Next. Call the list.
Item 1.
Not appearing for the appellant. Not the appellant was released on bail on 24th of December. Now he has sent a petition, prisoner's petition, stating that he has already served out the sentence. He intends to deposit the fine.
We have directed him to be released on bail.
Yes. Well, out of 10 years, on 24th of December, he was 9 years, 10 months, but with remission, he has completed the sentence.
All right, so he's been released on bail.
Now this is he has, after that he has sent this.
Mr. Sengupta, a person has been released on bail. So what can we
I've
do?
already
Tell us.
communicated. I've already communicated that order to. Huh?
Legal.
To find out from your DLSA secretary that he is being released on bail, why he is not furnishing bond.
Deposit the fine and go. Come up.
Let him deposit. Nobody stopped him from depositing the fine. Who stopped him from depositing? He has not been informed, Mr. Rai. This is lack of communication. Generally, what happens is when the substantive sentence is served out, the welfare officer says, deposit the fine, you can come out. And that is why he is following that track. Correct? All right, appellant is at liberty to deposit the fine. What more can we do? He has been released on bail. Your DLSA should take that exercise. All are in bubbles. Take up the phone, go to the office, talk to the lawyer concerned there, talk to the judge who is in charge, and tell him, sir, this is a bail order. So he did not deposit the fine. Next.
Made, please, Your Lordship.
Yes.
Lord, this is for quashing. I'll just take Your Lordship through the FIR. My learned friend had assisted Your Lordship on the last date. Your Lordship will have page 25. The complainant, he says he read some newspaper, and then on the basis of what he read in the newspaper, he has lodged this FIR.
Can you prepare a small supplementary with the judgment of the trial court, judgment of the single judge, and that of the
We've prepared this compilation, my lord, where we have the notices. Your Lordship may see it. If Your Lordship needs something else, I can do that also. Because there was an earlier, this was quashed.
We just need so that all papers are together in one.
All right, we can do that, my lord. There's no problem.
Please do that.
We can do that.
And we fix the matter for hearing.
All right.
Coming up for to be mentioned.
Yeah, it's coming up for to be mentioned.
So we fix the matter because you will argue for some time.
It's yes, for a short while, my lord. There are 3 or 4 issues I want to raise.
One is 17A
So,
applicability
no,
of 17A.
that will be my first point is it is completely malicious. Only it is targeting a particular party, and the whole thing is on the basis of a newspaper.
Party, sir, we don't see party as a malice.
I'm just going to
our argument is yes, the trigger of law maybe the motive is party, but if the underlying facts are a crime, then
that's the next argument.
Set a thief to catch a thief.
All right, that's the next.
All are thieves, right?
But the one who gets
thief.
caught, the one who gets caught is,
and someone is someone else's thief.
So one who gets caught is the thief.
Right. One who is it cannot be, I think, sir, your argument to say, so a pickpocket is prosecuted, so then the pickpockets are rampant in the society.
The second issue is that no offense is made out.
Right. That is not the more crux of it, whether any offense is made out.
So that's the second issue. And the third issue is that there are 2 procedural safeguards. One which you
committing corruption. One is prosecuted. That cannot be a ground to quash the corruption.
It is 17A. The third issue is 17A, and the fact that on the very moment the complaint is presented,
17A, the Supreme Court has expressed a bit of a doubt on 17A,
but it's left
which we
open.
understand because it's not a policy decision. Here, the person actually was tried to be given an advantage. So it transcends from policy to an actor.
So the whole basis of the allegation is that the director issued the instruction as a matter of policy that how it is to happen. I'll show that, I'll read that complaint to your lordships. So therefore, that also will come in. And also your lordship will consider the way how it has happened. 1 minute. The way how it has happened. The very day the complaint is filed, immediately the same moment, 1720, 20th May 520 it is presented, 17th May 520 the FIR is lodged, no preliminary inquiry, nobody bothers to apply mind what is to happen. That's a factor which your lordship will keep it in mind. Otherwise, on facts, the position is there is no public employment. It's a contract between AIMS and an agency. The agency has taken up to deploy people for a period of 4 months on a fixed salary. I'll read all that, my lord. If your lordship wants, I'll present the compilation and then once
Please,
make the submission, my lord.
I think it will take, you make your submissions, we will hear you.
Yes.
Before that, you make a compilation, even and on the day of hearing, you can present the
All right, no difficulty. And
papers in a
2, 3
compiled
judgments also we have compiled. That also we will
That
keep a
you give
separate
separately.
separate.
form. Mr. Mr. Patwalia, senior advocate, submits ingredients of alleged offences are not disclosed. Full stop. Prosecution is a product of political malice. Full stop. FIR was hurriedly registered without undertaking preliminary inquiry or sanction under Section 17, capital A of Prevention of Corruption Act. Full stop. The matter, learned public prosecutor opposes, accordingly, he prays for quashing of the proceeding. Learned public prosecutor opposes the prayer. He contends that the judgment delivered by the Honorable Single Judge quashing the proceeding on the ground of lack of sanction has been set aside by the apex court. Matter has been remanded before this court with a direction to be heard. Where is the Supreme Court direction?
Yes,
With a direction to be heard by a division bench, right?
Correct.
By a division bench. Hence, the matter is before this court. In light of the aforesaid, we have perused the materials on record. In light of the aforesaid submission made before us, we are of the view the matter requires to be heard out on merits, reheard on merits in light of the observations made by the apex court in so and so. Petitioners are directed to prepare a comprehensive compilation of all papers and place the same before this court. Advance copy may be supplied to the state. Matter will appear on, please give a
Any Thursday convenient.
Any Thursday is comfortable. Mr. Patwalia, this bench may not be available from 20th January till 31st.
That's all
so
right.
could we place it post 31st? Because then we only get one Thursday, that is 16th.
So then let it be 13th February if it is convenient.
13th of February. Mr. Public Prosecutor, 13th of February.
13th is all right?
13th of
13th. Rajdeep tells me, my lord, on the last date, your lordship had actually extended the no coercive steps order, but it didn't find in the order.
Interim order granted earlier. Interim order was there an interim order?
Yes, the honorable Supreme Court has continued it and said that
interim order granted earlier shall continue till 28th of February or until further orders, whichever is earlier.
Grateful.
With regard to interim order, don't worry. The basic premises being these three, we will look at.
Yes, that's the
real nub of the thing is whether ingredients of offences are discussed.
That's right. That's the crucial issue. That's the crucial issue.
In perspective of undue advantage.
Correct. That's the issue. That's
undue advantage. Public employment may not be a criteria. Allotment of contract done unduly is also within the ambit of unfair advantage.
I get it.
So we're just making
No, I'm grateful for that. I'm grateful.
So that you may address us.
I'm grateful.
Thank you, Mr. Patwalia.
Grateful. Very grateful. Very grateful.
Corrected. Next.
The remarks is, my lord, the defective TCR.
Let us see what are the nature of defect. If they can be ignored, that it could be, defects be ignored, paper books within 8 weeks. Like that. He's sat with Salim uncle.
My lord, 326, 307. Allegation is that, my lord, in respect of the land dispute, my lord, the quarrel took place. In respect of the FIR, my lord, after
Persons were injured, my lord, severe. मतलब ये हंसुआ, chest wall.
making of my lord, house and land in adjacent land.
Grateful, man. Yes, sir.
petition. My lord, he has said a report was handed over to
Handed
me.
the report, Lordship, it was forged.
Handed over to me, my lord. I checked it. Challan is not forged. My lord, kindly see one thing. My lord, I'll show one thing. Kindly see the report. My lord, I marked it, my lord. The marked portion kindly sees the then in the middle, my lord. Then he arranged to contact with the proprietor of Joy Matara Enterprise through mobile phone and asked him about the seized challan, wide invoice number such and such, date and such issued against the vehicle. Now, it is my vehicle, my lord. And he verbally stated that the invoice number such and such has been issued against vehicle number such and such date till 4th of August. So, admittedly, challan has been issued by the proprietor of Joy Matara Enterprise, which was, my lord, challan was valid on 4th of up to 4th of August, but due to shortage of labor, but kindly cease, my lord.
We are seeing with you. We want to see with you. Read the remainder. Instead of giving your reference points, you read the remainder. Read it loudly.
But after that, in this regard, after that, no coal was loaded to vehicle number such and such.
Again, you are looking at the sky. Can't you look at the document and read it? Can't you read it loudly?
But I'm reading. After that, no coal was loaded to vehicle number such and such. Then I asked him about the source of coal. And in this regard, as per direction of proprietor of Joy Matara Enterprise, the caretaker provide one tax invoice. Come challan dated such and such issued by Radha Impex in respect of the vehicle number such and such. Coal amount of such and such which is shipped to Joy Matara Enterprise, Moja such and such, PS Jamuria. And the coal was loaded from Charanpur, Bhonora Colliery. But it is very important now. After the previous IO went to Sadgram ECL PS and submitted prayer for verification of the seized challan of coal in connection with the case number, wide invoice number, dated such and such, issued against the vehicle number such and such. Now sees the reply. After searching the records, the area sales manager ECL Sadgram Sripur area stated that after investigation, it is found that the truck having number such, it's a different truck.
Again, lecture. Why can't someone speak of facts before your lectures? Please read it.
Having vehicle number such and such.
Patience.
But was loaded from such and such area. OC Charanpur on 16/5/2024 on OC Sri Rajshama Enterprise. And we are unable to give the information after release of the said truck. And also there is no information for the truck number such and such on dated 3rd of August such and such.
So this. Then next page.
My lord. Then area sales manager provides one computerized tax invoice dated 16 May 2024, wide invoice number such and such, which is billed to Sri Rajshama Enterprise, but there is some discrepancies in the tax invoice provided by the proprietor and ECL Sadgram. Because as per tax invoice provided by the proprietor of Joy Matara Enterprise, it is found that they brought the coal from Radha Impex, but as per tax invoice provided by the ECL Sadgram, it is found that they sold the coal to Sri Rajshama Enterprise.
Correct. Now you understand. These entire coal, which is supposed to be carried in your truck, is not issued to Joy Matara. It was assigned to one Rajyashama Enterprise and it had to go somewhere else. You using a different tax invoice, Joy Matara tries to give an impression that this is a coal which has been released to Radha Impex and Radha Impex has handed it over to them and you are supposed to carry this coal. So this is stolen coal.
But Joy Matara has not been made an accused.
Correct, should be made an accused. Joy Matara should be made an accused as per report. But does it protect you? Report is placed on record. Report shows that the coal, seized coal, had been seized coal was delivered by area sales manager ECL Sadgram to Messrs. Sri Rajyashama Enterprise and could not have, and the plea that the coal was received by Joy Matara Enterprise through Radha Impex is not correct, is not born from the records of ECL Sadgram. The coal was, this coal is sought to be, it also appears that the challan which was used to carry the coal was issued on 3/8/2024, but the coal challan which was used to carry the said coal through the petitioner by the on the petitioner's truck was issued earlier and was not valid at the time when the seizure was made. Without even taking these materials on record, it appears that the coal carried by the petitioner was never lawfully supplied to Joy Matara enterprise and accordingly is stolen property. In such view of the matter, we are not inclined to grant bail to the petition, anticipatory bail to the petition.
Number 8 has
मतलब
Item number
previous
10.
matter मतलब service वाला thing, service report.
In item number 12, my lord, I am for the petitioner.
My lord,
316 of BNS has been drawn up under the FIR. I am not the accused
My lord,
and I have no connection with the complainant.
a report from the police station of Guntur. My lord, that report has come. Lordship, kindly see this. This person is the owner of the gold shop. My lord, the Guntur police came over here and to find out the stolen goods, my lord. So the shop was closed, my lord. At the report, my lord, the last batch 2 page, my lord, kindly see the last batch 2. Where, my lord? No, he is the owner of the shop.
The shop.
Now, what is
In
the
West
allegation in the FIR?
My lord, Nothing against me,
Please,
my lord.
my lord, that
I apologize, my
my
lord.
lord, they in the FIR, the first paragraph, my lord, kindly see the allegation, the first paragraph, my lord, in the first page. This person has been implicated on the basis of co-accused statement. The main person, listen. Jain. You are Musarraf? No, my lord. He is my lord Jiaul Haldar, alias Bapi. Jiaul Haq Haldar, alias Bapi. And this man is
This man is, my lord, Ziaul Haq. জিন্নাত মালিক শেখ বলছে।
his Bapi.
Principal accused is already on bail. If I had to কোনটা এটা আমাকে কোনটা দেখাচ্ছে ভরপুর ভরপুর
So allegation is that he sold 330 grams to Bapi.
Bapi.
He is the owner of a gold shop.
Gold shop.
Okay.
Page 4, my lord, that fourth paragraph. Page 4, fourth paragraph. We have underlined the name of the petitioner and his implications.
This guy, he was working there. He sold it. Petitioner is the owner of a jewelry shop. He submits that he has no relation with he has no relation with
Jinnat Malik Sheikh
with Jinnat Malik Sheikh alias Gobed, the principal accused. He is ready and willing to cooperate with investigation. He prays for transit anticipatory bail. In view of the directions, he submits police personnel of attached to Guntur, Andhra Pradesh, came to state of West Bengal to arrest him. Apprehending arrest, he seeks transit anticipatory bail. In view of the direct law declared in so and so, we entertained the application and directed notice upon Guntur police station, upon Mongolgiri police station, Guntur, Andhra Pradesh. Report from the police station is placed on record. Gist of the report is to the effect that one Jinnat Malik Sheikh alias Gobed was employed was employed under one Musarraf in Guntur. He had handed over gold ornaments to, he had handed over 630 grams of gold to make ear studs. The said Gobed stole the gold ornament and it is misappropriated the gold ornament. Gobed was arrested. He made statement that he had sold 330 grams to the petitioner. Police came to the police came to West Bengal to search the shop of the petitioner, but the shop was closed and petitioner was absconding. Having analyzed the aforesaid materials in the light of the submission made on behalf of the petitioner, we note petitioner's implication is based on statement of co-accused Gobed, full stop. Admittedly, statement of co-accused before police is inadmissible in law. However, petitioner offers to cooperate with investigation and offers to cooperate with investigation in all lawful ways. Under such circumstances, we are inclined to grant transit anticipatory bail for 2 weeks. Petitioner shall, in the event of arrest, petitioner shall be released on bail on furnishing bond of 10,000 rupees to the arresting officer with 2 sureties of like amount and subject to subsection 2 of section 483 BNSS, full stop. The order shall remain in force for 2 weeks. In the meantime, petitioner shall be at liberty to approach the jurisdictional courts for necessary relief in accordance with law.
Mother, I'm extremely grateful, madam. I'm extremely
That's please give the citation.
But that report may be kept in the record. May it please your lordship. Allegation under section 354, 509, 506 of the old section and 12 of PROCEEDINGS. Allegation that this petitioner along with others used
65 Section 9 of the child marriage. Not the lady has been recovered. And they have
Victim
got
has
married.
attained majority.
They've got married.
All right. Victim has attained majority. Parties have married each other in view of the aforesaid development. We are inclined to grant and suit repeat.
Obliged.
Minutes 18, your lordship was pleased to reject the prayer for grant of pre-arrest bail on the last occasion. Further directed to file a report with regard to the arrest.
All right.
Raids are being held. So wanted in another case.
Two. Why proclamation attachment has not been issued? Huh? Why proclamation attachment has not been issued?
Well, in the other case, well, he has not been charge sheeted and neither his name is there in the supplementary charge sheet.
Has been issued. Proclamation has already been issued.
Prayer for WPA will be submitted soon after consultation of the last line of this.
Petition report is placed on record. Proclamation attachment, warrant proclamation attachment has been issued against the petitioner. In another case, in another case, in spite of efforts, he could not be arrested, and steps are being taken to issue similar processes in the present case. Investigating agency is directed to take necessary steps for apprehension of the petitioner at the earliest. Proceeding is dropped. Next.
I'm for the petitioner. 329, 115, 74, 35, my lord. Subsequently, 8 of the Coxwell
Lordship, I am for the petitioner.
Yes.
Lordship, this is a charge against kidnapping. That the principals accused are enlarged on bail. Last occasion, your Lordship, the CD was called for.
Accused on whose direction the entire kidnapping took place. Well, the de facto complainant is the wife, is the daughter-in-law. The father-in-law was abducted because of the previous animosity with the husband of the de facto complainant. Well, all the accused persons were
Petitioner submit that the victim has been recovered. He is not the principal accused. He prays for anticipatory bail. And a lawyer for the state opposed the prayer. We have considered the materials on record. Petitioner and others conspired to threaten the victim and her family members, kidnapped the victim and demanded gold. And demanded gold. Huh.
There was a dispute regarding demand of gold in Andhra Pradesh. The victim's husband thereafter went to Delhi. Now the father-in-law was kidnapped on the instance of the present petitioner and the other henchmen who were arrested
For the purpose of the gold
purpose.
and demanded return of gold. Keeping in mind the nature of crime, we are of the opinion this is not a fit case to grant anticipatory. Next.
কত এটা? 23. The victim had been notified.
Yes, Lordship.
It is the report.
I have submitted. Has it got
Mala, this is 164. You promised to marry.
Petitioner, we have considered materials on record, including statement of the victim. She is a major lady.
41 is
Full stop. Whether there was love, there was a romantic relationship between the parties. Allegation of forcible rape in her statement.
My lord, I am for the petitioner. My lord, 420, 467, 468. My lord, I am filing a supplementary affidavit pursuant to leave granted. My lord, I am a former ASI, my lord, working in the ATS section of the West Bengal STF. My lord, I have become, my lord, a victim of, my lord, politics in my own department. My lord, in 2023, my lord, for gallantry, I was awarded a Shaurya Padak. My lord, thereafter, my lord, I became an eyesore in my own department. My lord, in the month of August 2024, my lord, a frivolous complaint was made by one of my colleagues. My lord, one Mr. Ghoshal, my colleague, that I have issued a 160 notice in his name. My lord, and particular phone number was referred. Now, my lord, the complaint was made in the month of August. By, my lord, November 2024, within 3 months, my lord, in breakneck speed, my lord, I was dismissed from service. My lord, the day I was dismissed for service, the day was 22nd of November 2024. My lord, on the same day, this FIR has been registered, my lord, referring to incidents which took place in January. My lord, the victim of this case, my lord, one Mosiar Mullik, he himself has not lodged the FIR, his brother has lodged it. My lord, Mosiar was the source of STF. My lord, he used to work as the source. My lord, he was double-crossing me, he was double-crossing my department. My lord, over that, my lord, Mosiar, his elder brother, my lord, along with, my lord, another advocate, my lord, has roped me into this criminal case. My lord, the FIR, if your lordship will see, my lord, I have annexed a typed true copy at page 6A of my application. My lord, the allegation is that, my lord, this Mosiar, he received, my lord, a summon by way of through DTDC courier, and in that summon, upon receipt of that summon, Mosiar's family on its own goes and approached a lawyer, namely, my lord, Ronnie. Now, my lord, Ronnie, my lord, says that I will sort out this case. Don't, and my lord, that summon was not from STF or anything. That was a false Delhi case, or summons whereof was received by Mosiar, my lord, by way of, my lord, courier. Now, my lord, their family on their own go and approach a lawyer. The lawyer says, I will sort it out. Give me, my lord, give me money. My lord, they give money to that lawyer. Till there, my lord, I am nowhere in the picture. Since Mosiar,
summons करता है पैसा लेता
since
Yes.
Mosiar was the source of STF, my lord, in an independent, my lord, interaction, my lord, I asked him to come to the STF office. That has got nothing to do with the, my lord, summon received and, my lord, Bonnie.
what Ronnie is
My
doing.
lord, the
How will you know?
entire allegation,
Who is asking money from whom? How
no,
you know?
Bonnie took the money, my lord.
That is what we are saying. Who lawyer he pays lawyer for summons? You wanted intelligence. Mosiar came and now Mosiar is implicating you.
Lordship.
Belated.
And my lord, and another issue is, my lord, that it is not the case made out in the FIR also, that, my lord, it was on my advice that the Mosiar's family approached the lawyer. There is no connection there.
No.
They independently on their own, upon receipt of that summon by courier or false summon by courier, they approached that lawyer.
Yes, Mr. Joydeep Rai.
And, my lord, I have already been dismissed from service, my lord. I have a
Why should you go to
young child, my lord. My lord, kindly consider this, my lord. I have already lost my job, and within 3 months, August the complaint was made, November I was dismissed, my lord. The entire politics in my department, my lord, I have become a victim, my lord.
To what extent you have gone? You have also issued a summon against your colleague.
Kindly see, my lord, my supplementary. No, not against my colleague. He was a source of the STF.
Mosiar is source. Why were you dismissed? Not for Mosiar. To whom did you issue the summons?
To a person called Jamal.
Who is Jamal?
Jamal is an accused in a particular case. The case again, so far as, my lord, the summon case issue is concerned, my lord, the allegation by my colleague Boydurjo is that I signed as Boydurjo. Now, my lord, kindly see, my lord, my disciplinary proceeding statement. Jamal comes, he says, I come to the STF office, I report to Boydurjo Ghoshal. My lord, kindly see, my lord, the supplementary affidavit, page 13. There, my lord, Jamal gives the statement during my disciplinary proceedings that I come and meet Boydurjo Ghoshal. Boydurjo says, please talk to Shantanu, the petitioner herein. Shantanu Babu will take care of everything. Then the Shantanu interrogates, my lord, Jamal, and then Boydurjo says that, all right, Shantanu Babu will record your compliance, and he leaves. It is not that when Jamal comes to the STF office, Boydurjo said there is no such notice, please go. That is not the case, my lord. Kindly see Jamal's statement. in my supplementary affidavit, my lord.
Mhm.
I am being made a victim of the politics
Correct.
in my own department, my
Yes.
lord.
My lord, taking advantage of his position.
No,
and-
that position we understand.
My lord.
What is the stance of Boidurjo?
My lord, may I submit, my lord? My lord, initially, my lord, in a case of Haskali, which was not registered with the STA, in that particular case, he issued a notice forging the signature of his superior, which was accepted during the departmental proceeding.
Hmm.
And my lord, he issued the notice to the Jamaluddin. My lord, and
Who is his superior?
my lord, his superior was Boidurjo Ghosh.
Good.
And my lord, in this particular case of Haskali, he used a mobile number that is there in the departmental proceeding. My lord, I am placing it. And my lord, same number has been used in this case also. We have seized the, my lord, voice note from the de facto complainant, whereby, my lord, he instructed the de facto complainant to come to the particular place where the STF office has been located. And inside the STF office, he collected 10 lakhs. And thereafter, he purchased a flat immediately after 2 months. I have collected the deed also, my lord. That is of 39 lakhs. My lord, he himself went to the downstairs, and my lord, he took both the, my lord, de facto complainant and one accompanying witness, along with the lawyer who signed in the visitor's slip. My lord, the voice note should be, my lord, inquired whether that voice note is of this petitioner or not. And my lord, same number used in
Same
both the
number.
cases.
My lord, I'll provide the sample, but my
will
lord,
do
the only that is the connect, my lord, that the Boidurjo is implicating me being my colleague. That number is the common thread, my lord. Boidurjo implicated me in the disciplinary proceedings by using that number, which is not in my name. And the day I was dismissed, on that day, this case was started with regard to in the month of November, with regard to an incident of January, my lord. And by using, my lord, the elder brother of my source. That is where, my lord, Boidurjo, and kindly see, my lord, page 15 once, my lord, Jamal's statement. Kindly see what Jamal says, my lord. আমি প্রথমে এসআই অফ পুলিশ বৈদুর্য ঘোষের সাথে দেখা করি এবং উনি বলেন যে এই বিষয়ে এএসআই শান্তনু মন্ডল অফ এটিএস সেকশনের সাথে সঙ্গে কথা বলুন, উনি এই বিষয়টা দেখছেন. This is Jamal's statement with regard to Boidurjo, my lord. Boidurjo is implicating me in these cases, my lord. He has got me removed from service.
All right, take
He
down.
wants me to send me to jail.
Petitioner, he was an employee.
I will give my voice samples, my lord.
Petitioner is an employee. Petitioner was working as sub-inspector.
ASI, my lord.
Assistant sub-inspector of ASI of police in STF, West Bengal. Full stop. It is alleged that he submits, he had a decorated track record. This created this created jealousy, and he has been falsely implicated on accusation of raising demands from individuals, and he has been falsely implicated to extort money from individuals by abuse of his official position. In a trumped up charge, he was dismissed from service. First information report has been belatedly lodged, alleging he had summoned one Moshiar Molik to the office and extorted money. This is Moshiar is a source of STF, is his source, and the allegation of extortion is out and out false. Accordingly, he prays for anticipatory bail. Learned lawyer for state and de facto complainant opposed the prayer. They contend petitioner had abused his official position and demanded money from one Jamal Sheikh, and accused by.
No. The allegation in the FIR is I demanded money from Moshiar.
Sir, this is their submission with regard to the disciplinary proceedings.
Lordships.
demanded money from one Jamal Sheikh, an accused Jamal Sheikh, by issuing a purported notice in the name of his superior Boiturjo Ghoshal. Disciplinary proceeding was initiated against him on that source. The mobile phone which was used in the said operation is the same mobile phone which was used to call Moshiar to the police station and extort money. A voice recording of the petitioner has also been collected during investigation. His custodial interrogation for progress of investigation is necessary. We have considered the materials on record. Petitioner has been alleged to indulge in similar acts of extortion from various individuals. On the first occasion, Boidurjo Ghoshal, his superior, lodged complaint alleging that he had forged his signature on forged his signature and summoned one Jamal, an accused, to the police station. Then he extorted money from him. On this score, disciplinary proceeding was initiated and petitioner has been dismissed. Mr. Chatterjee, senior advocate, submits Jamal in his statement, claimed that he had met Boidurjo, who asked the latter to meet the petitioner. This statement, according to him, this statement is exonerative. We are unable to subscribe to this submission. Boidurjo, Jamal's statement requires to be assessed in backdrop of other materials on record, Boidurjo was presented. Jamal met Boidurjo at the police station, and noticing the summons which appeared to have been issued by the petitioner, he had referred Jamal to the petitioner. This does not exonerate the petitioner as contended. On the other hand, mobile phone utilized to summon Jamal is the same device which was used by petitioner to call Moshiar and extort money. Full stop. There are other materials, other forensic voice recording of the caller also requires to be voice recording of the caller has been seized during investigation. In light of the aforesaid incriminating materials, we are of the view there is sufficient and cogent material implicating the petitioner in the crime, and it cannot be said to be a product of malice. Accordingly, we are not inclined to grant anticipatory bail. Will come after 5 minutes.
Lords.
28 Lordship, I am on behalf of the petitioner. This is the affidavit of service.
I am for the de facto count.
Lordship, the allegation is Lordship promised to marry. And the last Lordship on last allegation on 2nd September, he has Lordship tortured, assaulted the de facto complainant. But that is not true. On that day, he was Lordship at Jammu and Kashmir, he was on duty. Lordship, this is, he was a BSF personnel, it is to this one. This is the Lordship.
He is my lord, constantly my lord, threatening the
It is to this
victim,
one.
my lord.
Lordship, he was on duty on 2nd September, Lordship. He joined the duty on 2nd September. Any minute. ও ডিউটিতে ছিল ওই দিন
Petitioner had demanded petitioner she had been there was a meeting had talks. Petitioner I and petitioner was how to base what as at the streets of street
Jammu and Kashmir.
Yes, it's there.
There is
Sorry.
জানি কোনো ডকুমেন্ট Lordship, he is in Jammu and Kashmir, he is in BSF Lordship. Your Lordship kindly. Lordship, from Jammu and Kashmir, Lordship, it is 6 months, Lordship. Twice after 2 weeks, after 2 months, Lordship, your Lordship kindly. Kindly, Lordship, he has to come from Jammu and Kashmir. Lordship, kindly, kindly, Lordship. Lordship. No, no. Lordship.
But I am appealing for petition.
The report is lying with you. Can you make it a short pass over your
And on the earlier occasion, your lordship transferred the investigation to CID, my lord.
CID? Can you make it a short?
case and counter case over the issue of processing jute. We also sustain injury. Our injury is more grievous than the defective complaint. Charge sheet submitted.
Your statement under section 164, my lord, 120, 130, and my lord 128. And my lord, injury report is 90 and charge sheet submitted. Charge sheet submitted, madam.
Investigation complete.
My lord, 37, I am for the petitioner, my lord. I am praying for anticipatory bail, my lord. Regarding what is claim the share of the land.
Yes, Miller. Sorry, Miller.
Money dispute between the parties claiming the share of the land and non-payment of rupees 1,92,000.
I have folded Miller 57. That intestine came out. Can you see?
I think I found the solution to the problem, my lord. My lord, the statement of account of SBI, because my lord, 24th, 25th, 26th were 3 bank holidays. So my lord, here's the statement, my lord. Of the person to whom the money went, with the connivance of Gautam Rai, who is still in custody, my lord sees on the top, my lord, the balance was 0. Then 50 lakhs comes into his account, the main accused, my lord, who has now absconded on the top. Then my lord sees that 25 lakhs, which my learned friend was saying, it went to Axis Bank, which I've annexed to your lordship.
Page 18.
As page 18. 19, page 19.
22nd, it went to Axis Bank.
Yes, see here is, my lord, your lordship sees the numbers are the same. Page 19, 19.
Page
19, 19. Of my petition, my lord. Sees the first entry, my lord. 22nd August. And sees, my lord, tally the number, my lord. It is same.
Yes,
5202 is same, my lord. So the 25 lakh goes there. And by 27th, my lord, if your lordship sees the State Bank account, it is reduced to a double figure. Okay, দিয়েছো এটা? ওই SBI এর এটা কাগজটা এবার বুঝে গেছি তো ব্যাপারটা।
So, 28, 26 holiday.
Then, my lord, from that SBI account, 7 lakhs, if your lordship sees, I don't have it, my lord, 7 lakhs from the goes to the account of Mohammed Cash at Bank of India.
7 lakhs.
7 lakhs. And sees, my lord, the last entry, what, how much it comes out? 2 lakh cash withdrawal also.
Correct.
And my lord, the CCTV was, my instructions are, my lord, the CCTV was seized.
But why you were giving a wrong number with wrong account number of Rahil?
No, my lord, that's 30338.
Huh?
Rahil number.
Page 18.
Page 18.
18, your letter.
SBI আমাকে জানালো আমি সঙ্গে সঙ্গে ওটা block
Transferred 25 lakhs to his account, namely Rahil, having account number so and so.
Yes.
So Rahil's account number is not so and so. Rahil's account number is Rahil's account number
30 something
2028 92028 92028.
That's the SBI account number.
SBI SBI
Right.
ওই টাকাটা অ্যাক্সেস চলে গেল
SBI account
account now.
এটা অ্যাক্সেস
And the other one is Axis.
Yes, where is the axis?
19, my lord, page 19, 19. 18, my lord, the number is there. 5 to something, my lord.
Huh?
My lord, it's the Axis account 9240.
Joint account, that is Yasmin baby.
His wife,
Begum.
my son of.
Then Yasmin.
Hmm.
9086.
Well, 924, your lordship sees it, it is same.
That we have seen.
Same statement of account.
Account number of 908607. RTGS from Rahil.
From SBI, my lord, RTGS.
আমি জানলাম SBI তো জানালো ওই অ্যাকাউন্টে 22 টাকা গেছে সঙ্গে সঙ্গে ব্লক করে দিলাম। চারবার অ্যাটেন্ড করেছি আমাকে এক্সপ্রেশন ছিল দিয়ে দিয়েছি 22.8 this is
from
25
SBI?
lakhs 25 lakhs 47,000 but the amount going into this is only 25 lakhs.
Yes.
Why?
Well, amount going to Axis Bank is 25,000. Well, the charges for RTGS, the charges for RTGS, that will be deducted from the amount.
But this is in the name of Yasmin.
Yes. Not Yasmin, my lord. Rahil on the top, my lord.
Oh, Rahil.
Yes, oh, Rahil, right.
Son of Yasmin.
Son of Yasmin.
Son of Yasmin.
And my lord sees the transactions between 21st and the.
There's some
But firstly, what was bothering me is this annexure, that how did the present petitioner,
We're not concerned about botheration. We're concerned about the explanation.
well, I am explaining. First, kindly bear with me for a moment. How did the present petitioner have the knowledge at all that out of 50 lakhs, some portion have been credited to Axis Bank? How is Rahil? He holds an account in Axis Bank and he messages the manager. Well, this is one part.
That may be internal explanation material, the way your police officer knows he is a complainant.
But it is there.
Now-
How SBI is giving it to me.
One thing. Your Lordship kindly comes to page 428. Some clarifications was Purota de.
428.
Page 420.
Key, it, key.
Some clarifications were sought. Purota da. Purota. Page 428 in the third volume.
Properly.
Now the standard operative procedure, how texts are cleared, what are the norms that are to be followed? Lordship kindly sees 428, point number H and I. Now to this he replies at page 430.
Data.
But he kindly sees the entire thing, especially point number 3.
Yes.
Well, it is he who had passed the check. Now, if your Lordship sees his reply, what procedures are to be followed? The complainant was supposed to receive a call because the amount exceeded 2 lakhs.
Right.
Complainant did not receive any call, firstly. Well, there are CDRs between the bank, which the present petitioner has
Question is who is clearing the check? The RTGS clearance is made by him or
Uttam Rai.
Uttam Rai.
This is what he says. I passed the check. Lordship, please
Where?
point number 3 at page 430.
Pass the check, man. It will be deleted, debited from the account of BD Enterprise.
Past, I mean.
Yeah, yes, the check.
Difference. The final nod is by him. He has further clarified it again at page 484. Now, my lord,
Tak na,
one of
দেখাচ্ছে।
the co-accused,
যেটা আমি কাল-
Arindam Mitra,
In custody, না?
in custody.
ডেটটা বলতে পারবি বেটা?
Second December.
He's saying he passed the check for
Because of 5 lakhs, it had to go through 50. That is the reason why he cited.
92028.
Yes.
That is the
Sahil's account. in
Right.
SB. Now, Lordship, even the earlier step that needs to be complied with is the call to the.
Well, that has been done. That has been done.
Now, on the contrary, what has happened? One of the co-accused, Arindam Mitra, made 4 calls to the bank, which was received by the present petitioner. The CDR details are at page 215 onwards. Arindam Mitra was continuously pressuring, why is the check not being cleared? So even this did not bother the present petitioner that there might be something wrong. Well,
এই দাঁড়ান না, ওকে বলতে দেন।
to submit, was it merely negligence or was he
Involved.
facilitating the entire procedure? Well, this is one aspect. Entire incident happened on 21st of August. 22nd of August, complainant with his son visits the branch, speaks to the present petitioner, brings to his notice about this fraudulent transaction. Why did the present petitioner wait till 27, 5 more days, to inform SBI to debit freeze the account?
May I say this? Finished? You're finished? Achha.
Because the entire money by that time, by way of ATM withdrawal, cash withdrawal, RTGS, had already gone out of 028.
The complaint was made to the petitioner on
22nd itself.
22nd.
On 26. No, the page 22 is to branch manager by.
That's on 27th.
That is on 27.
But because the period was 24th, 25th, 26th, or 3 bank holidays. 3 bank holidays. So, Malat, SBI gives me this statement. I go personally and get the statement which I've given to your lordships. And Malat, if your lordship sees, the DD department, who is now looking after it, Malat, sees my letter to them on the 30th of, at page 30. These are the things which I handed over to them. Because I was called on 4 occasions, I've appeared on 4 occasions, and these are the things which I have stated to the detective department, which took over the investigation. And Mother, your lordship, in front of your lordship, you see all document-based investigation. Everything has been done. Gautam Rai CCTV has been seized. Gautam Rai has accepted that he took 5 lakh of rupees.
The only thing is that whether the present petitioner may also be a recipient of some.
Well, there has to be somebody who says it, Malad. There has to be somebody, Mr. Mr. Sinha.
Or was there some intention to facilitate the entire?
Well, I had called the BD Enterprise. Then they came, Malad. Then I submitted all these documents to the investigating agency.
Petitioner is the.
Did he himself comply with that?
Yes.
SOP.
Yes. No, the SOP of telephonic conversation is not done by the manager.
True, my lord. He has received the phone call by the co-accused Arindam Mitra not on 1 but 4 occasions within period of half an hour seeking
Yeah.
explanation.
Very,
Why is this not being
very
asked?
dangerous thing. Very dangerous thing. Explanation actually does not address that change of the account number.
My special assistant Gautam Rai. He was sitting in that, my lord. I've given that letter, my lord. I've sent that to the bank, my lord. Well, just give me a minute, my lord. 1 minute, my lord. My lord, Gautam Rai was the person who took the check, and the CCTV footage shows that please. The CCTV footage shows that gentleman who had deposited, Gautam Rai hands him over the check, which was in respect of BD Enterprise going to Chittaranjan branch. And then after half an hour, he comes and gives it to Gautam. Then the RTGS takes place. That is the CCTV footage, my lord.
So after your clearance, the
Yes, they took it, and then the forgery happened by Gautam Rai.
But
That is nowhere clear.
but Mr. Mukherjee, your explanation is I being branch manager passed the check for RTGS of
BD Enterprise
of 50 of SBI account number 92028. 92028 was the changed
of Rahil.
Yes.
Of Rahil.
Yes, of Rahil.
But that on the check is a overwriting.
Overwriting. That was taken at 4 o'clock in the evening as per the CCTV footage.
That after that you had cleared the check.
No. Mala, which page, Mala? Your lordship saying
which page? You see this, you see your response statement. The response statement in paragraph 3.
Just give me a second.
We would have understood you had cleared it for
BD.
BD.
Yes, I
Then
get
he makes the change. That is not that. You made the change for this.
Number 3.
Clearest change, it cannot finish.
My lord, what happened? I'll tell the lordship. My lord, subject to corrections, my lord, see Gautam Rai erroneously made the entry of RTGS for 5 lakhs.
Right.
Then, my lord, to come to 50 lakhs, the entry of the number of Rahil was done by Gautam prior to that.
Prior to that.
That is why it isn't so.
So you don't say that
I had aware of BD Enterprises account number.
You don't say that the account number is corrected and the check amount is corrected for RTGS.
No, I am not supposed to say that. That's only Gautam Rai's duty. Special assistant only for RTGS.
Correct, but you are clearing the check for an
RTGS.
Correct. For whatever RTGS or physical.
I get your lordship. Yeah.
The account number is overwritten.
The account number which has been overwritten was the account number of. Mala, it came to me because Gautam deliberately what he did, the amount was 50 lakhs. What he did, he made an RTGS, as your lordship knows, RTGS has a form. That form, signature of customer and emitter. So, Mala, the question was, Gautam Rai deliberately made it 5 lakhs because I had to, without the manager's permission, that 50 could not have been made. So, he comes with that, and on the backside, Mala, is the number written. So, now he has, but if he was at fault, he would not have handed over the check to the police officer by himself. Your lordship has to appreciate that also. So, but now the question is, this is it may be a negligence on his part, but he never participated in the commission of the offense as such, my lord. And we're all document-based investigation. He's the branch manager of this area. Now, I'll leave it to your lordship, my lord. Hey, my lord, my lord,
But he is clearing the check in favor of 028 instead of 773, and he can see it. It's not that he has cleared it before the change.
No, it's after the change.
It's after the change.
That is what I'm saying. How would I know about the number of PD Enterprise?
After the check.
After the check. That is what I'm saying.
After the check.
After the check.
After the 773 was cut through to 228 was incorporated.
That
He
is what
has
I'm saying.
passed.
It's not a question of passing, it's a question of RTGS being done.
Yes,
And
allowing the process to happen.
well, whether it's negligence on his part and whether custodial intervention is required or not. After so many pages, I leave it to your lordship. I think we both have used our lordship's time a lot.
Custodial interrogation is necessary in this sort of cases for the purpose that the money has not been recovered.
No, they'll get it. Well, bank has to pay too. They have paid the money to be the enterprise. It's under the law, my lord, FDIC. It's an insurance. Any money there becomes an insurance.
So your employer suffers.
True, not for fault for mine, my lord. They'll take it from me if they feel. Because one of the department proceedings is going on. So that I will be suffering there on a monthly transaction. Whether custody warrant, where 600 pages, I met them 4 times, my lord, and I have produced the documents to them. It's not that I have hidden the documents.
All right.
I leave it to you.
Petitioner is the branch manager of Indian of Punjab National Bank. He contends that one Gautam Rai, special assistant, was responsible for RTGS transfer of a check of rupees 50 lakhs to the account of one Muhammad Rahil instead of PD Enterprises, the payee of the check. He had reported the matter. Coming to know of these facts, he reported the matter to the police as well as to the investigating to the police. He also intimated Axis Bank to stop payment, to freeze the account of Mohammad Rail where the amount was transferred. Learned accordingly praised for anticipatory investigation is based on documents and custodial interrogation is not necessary. Accordingly praised for anticipatory bail. Learned lawyer for learned additional public prosecutor opposes the prayer. She submits petitioner being is the bank manager and had admitted that he had cleared the check. He had passed the check for RTGS transfer to SBI account of 399,308,92028. Full stop. The check leaf shows that there was overwriting. The check leaf shows there was overwriting. There was overwriting with regard to the account. Check leaf showed that the account number was had been altered from 421,985,18773 to 399,308,92028. Full stop. He without inquiry, he had passed the check for RTGS transfer. He made though the matter was reported, though the fraud was reported on 22nd of August 2024, he lodged complaint on 27th August 2024, within which period the entire money had been siphoned away. We have considered the materials on record. Petitioner did not have the primary responsibility for RTGS clearance. For RTGS clearance, which had been entrusted to one Gautam Rai system assistant. However, he admits that he had passed the suspect check for RTGS clearance as bank manager. The suspect check showed an alteration not only in the amount. Suspect check shows an alteration shows an alteration with regard to the account number of the payee full stop. This issue this issue payee whether the clearance by the branch manager or petitioner contends he was unaware of the check. Petitioner contends he was unaware of the account number of the payee's account number and had relied on the impression given to him that Gautam Rai had relied on the impression given to him by Gautam Rai that the same was an innocent error. Whether the failure of the petitioner was one of negligent oversight or conscious participation in the crime is a matter to be gone into at the appropriate stage of the proceeding. He has also explained that he has explained away why the complaint was lodged, that he reported the matter on 27th of August 2024 as the intervening days were bank holiday to the respective banks, as the police also was on 27th.
No, first traffic was on 27 from me, but BT Enterprise lost it early.
Acha, to the authorities concerned as
On 22nd itself.
FIR on 22nd.
No, FIR on 25th, because when the complainant approached the police authorities,
So
he was directed to do with the bank.
So
So he
see,
had informed the bank at the earliest, I mean the present petitioner on 22nd itself, but immediately on 22nd he had informed the present petitioner.
were bank holidays, full stop. In
Mala 22nd and 23rd was not a bank holiday. Communication to SBI is only on 27th, not 22nd or 23rd.
24th, 25th were bank holidays.
26.
He received the information on 22nd.
24th, as there were intervening bank holidays. Be that as it may, the investigation revolves around documents which have been recovered. Nothing is placed on record to show that money had flown. Money was money had been routed through the accounts of the petitioners, which would require custodial interrogation for its recovery. Under such circumstances, we are inclined to grant anticipatory bail. Subject to conditions, petitioner shall meet the investigating officer once in a week until further orders. See, police does not register till 25th. Can we say police is in connivance? Although
That is what I wish to submit, but I cannot. That's exactly what.
no, it may not be so. It may not be so. These are all bureaucratic laxities, and the victim citizen suffers for this. Next.
Well, the petitioner, a complaint has been lodged under section 406, 17, 420, and also under section 267. The fact relates to way proceeding and a compromise has been arrived at. A compromise is arrived at rupees 89 lakhs, out of which 75 lakhs has already been paid on 2nd May. And there are no default in paying the installment. All of a sudden, don't going to report to it.
Yes. Petitioner submits that he had taken a loan from the complainant bank. He failed a original proceeding was instituted before the Debt Recovery Tribunal to recover dues. A decree on settlement was passed and has been substantially executed. At this stage, a criminal case has been registered. He prays for anticipatory bail. And a lawyer for the state submit that petitioner had used forged documents to obtain the loan. Collateral. Okay.
Sold it to others. Commercial activity, that is the only allegation.
He took a home loan, started business. Petitioner had taken a loan. Petitioners took a home loan, but utilized the same for commercial activities. We have considered the materials on record. A decree on compromise had been executed by and between a decree on compromise had been passed between the petitioners and the complainant bank. The decree has been substantially executed, realized. Decree amount has been substantially realized. Investigation relates to documents and does not require custodial interrogation. Accordingly, we are inclined to grant anticipatory bail subject to condition meet investigating officer. Next.
Can be taken up on Monday,
Monday.
Huh?
Give a copy, Mr.
Okay, I just.
Give 420.
420, 498.
420, 498.
Widow. Complainant is the widow of a son who died, and the present petitioners are 18 number, all relatives of the.
Siphoned away all the money.
We'll see who has hyphened of what.
Siphoned away.
From my money.
Siphoned away all.
Chal, facts. Abar? Well, I'll show to you, Lordship.
You file a domestic violence. All I let us do like this. Whatever jewelry you return.
Wait.
I see claim of my husband.
I'm the mother-in-law. Mother-in-law.
Where is the money? Where is the money?
My account. My account. It's the mother.
It is fixed.
Yes, fixed. 7 lakh mother amount 7 lakh 9,000 is money which is with money. Please I don't want to go into the details because just I got the documents. I don't want to say something which may prejudice Monday.
But the petitioner, my lord, the suo motu complaint has been registered, my lord. The bomb blast incident has been taken place when the Bathanbadi of Moja Sheikh, my lord. And my lord, we found that Bathanbadi Moja has been damaged due to bomb blast injury, and there is, and the my lord, leadership of Shahjahan Sheikh. Shahjahan Sheikh arrested, my lord.
We have considered the materials on record. Petitioners were involved in
The statement of the Shahjahan
bursting
Sheikh.
bombs. They have absconded for almost 2 years, for 1.5 years. Under such circumstances, we are not inclined to grant answer. Next.
Grateful, my lord.
44, my lord, I am the petitioner, my lord. It is the identical petition in the same offense, my lord. The present petitioner is the brother of the earlier complainant. The lordship granted anticipatory bail. There are earlier occasion is 20%, my lord, made a accused person. The present is a 27%, including the housewife. That page, my lord, kindly see the order passed by your lordship earlier grant anticipatory bail. Lord, civil injunction is also granted.
Receive the case diary. Kindly makes it
Not today. Not today. Next.
I'm for the petition. Allegation under section 399 and 399 and 402 of the Indian
We
Penal
have
Code.
considered the materials on record. No incriminating, no firearm was recovered from the petitioner.
It is absconding one.
My lord, it is alleged that
What was recovered from others?
Others recovered one haswa, one iron rod, and one knife.
All right. We have considered the materials on record. Petitioner has been implicated on the statement of co-accused. Articles seized are incriminating articles have already been seized. Under such circumstances, we are inclined to grant answer. Next.
He's absconding since 1 year, 8 months now.
That is your most important
No,
point.
and, injury
Was the
report-
allegation announced
injury report.
341, 326,
And he's the prime- he's a
What
prime
is the
charge
injury?
sheet has been submitted.
with knife, my lord.
Page
Injury report, page 7 and 40, my lord. Sharp cut injury, my lord, with knife. And he's the
Few days
principal-
he was hospital and have been discharged.
He was initially treated at Haldia, then he was brought to SSKM, my lord.
Petitioner, page 48.
40 and 7, page 7 and 40.
We have considered the materials on record. Victim suffered serious, grievous injury, grievous injury with a sharp cutting weapon, that is knife. Petitioner had absconded for a considerable period. Accordingly, we are not inclined to grant answer. Next.
My lord. 420, 467, 468, 471, 34, my lord. I am the identifier of a deed, my lord. The purchaser and the deed maker both are granted anticipatory bail, my lord.
Allegation against him is that he
We have
identified
considered
someone
the
else as
materials
the
on
de facto
record.
complainant.
Co-accused who had purchased who had executed the sale deed, as well as the purchaser have been granted pre-arrest bail. It is contended petitioner had identified the complaint,
Someone else as the complainant.
Had identified co-accused bracketed who is on anticipatory bail as the complainant. Petitioner is not the beneficiary. Keeping in mind these facts,
My lord, not the co-accused, my lord. This petitioner identified another lady as Rupa Dotto, who is the de facto complainant.
correct. So that lady is the person who transferred. How can that be? There's a transfer, sale transfer.
Rupa Dotto is the seller in the deed.
Correct. So who have been granted bail?
The person who purchased.
Okay, no.
And my lord, the deed maker is also granted bail, my lord. I am the and on the same date, my lord, this Rupa Datta executed four deeds, my lord. He is now complaining about only 2, my lord.
All right. We have কি বললাম যেন? Co-accused who has been granted bail is the innocent purchaser for value. full stop. Petitioner identified a different person as the vendor. In view of his role in the crime, we are not inclined to grant and suitable. Rejected. Next.
My lord, can you fix this matter on Monday?
Why?
All the cyber crime, my lord, KCID has not received, my
Monday.
lord.
Great. Next. We finish it.
Well, I am for the petition. My lord, one Lalbanu Sheikh's, my lord, Lalbanu Bibi, my lord, is the complainant, my lord, father's wife, my lord. There is a dispute, my lord, matrimonial dispute. Matrimonial dispute, my lord, and this
Newly constructed house of the de facto complainant.
We have considered the
My lord,
materials
we
of
are-
record.
we are the, my lord.
Petitioner, dead body was found in a house which is under the control and custody of the petitioner.
No, my lord, no, my lord.
Huh.
No, my lord.
De facto complainant's one's newly constructed house, the dead body was found, which was antemortem and homicidal intent. A boy was murdered. No, my lord, motive is there, so there is dispute between the petitioner and the father and mother of that victim.
My lord, Lalbanu Sheikh is the my lord wife, father's wife. We are the Lalbanu Sheikh's mothers and my lord maternal uncle. We are listed another place, my lord. This Lalbanu Sheikh is the complainant's father's wife. My lord, we have done nothing, my lord. My lord, he is a handicapped baby, my lord, boy, my lord, and he has a addiction in, my lord, the mobile phone. My lord, kindly see, my lord, the FIR, my lord. My lord, we have done nothing. We are not staying there. It's a Lalbanu Bibi.
1 second. So Lalbanu is arrested.
Yes, my lord, granted bail.
By the
Lalbanu is arrested. And these petitioners are relations of Lalbanu.
Yes, my Lalbanu's mother, my lord, and the Lalbanu's maternal uncle. Then another house, my lord. They are living in another village. my lord.
All of them took part in the commission of that murder.
Anyone saw anything?
No.
Charge sheet filed. Petitioners submit that there is no direct evidence connecting them with the murder. They have been falsely implicated out of suspicion. They pray for anticipatory bail and a lawyer for the state oppose the prayer. We have considered the materials on record. Dead body of one Manirul Sheikh was recovered. Who died? Manirul na to? Minarul. Who was murdered?
My lord, Noor Islam Sheikh.
How Noor Islam is connected with Lalbanu?
Yes. Noor Islam's uncle was the husband of Lalban. There was dispute between the husband and wife. So wife took revenge. It is the allegation.
Acha. Dead body of one Noor Islam was found in the was recovered. Lalbanu Sheikh is the Noor Islam is uncle-in-law of Lalbanu, a co-accused. It is alleged that Lalbanu and his husband had matrimonial dispute and the uncle-in-law was murdered on this score.
Noor Islam is the niece of Lalban. Nephew of the Lal.
Uncle, Lalbanu's husband's uncle.
No, husband's my lord.
Uncle.
Husband is the uncle of this beauty boy.
Noor Islam, my lord.
Nephew.
Husband is the uncle.
Yes.
Acha, uncle-in-law is the niece of Lalbanu's husband. Uncle-in-law. It is alleged that Noor Islam was murdered on this score. Petitioners are the relations of Lalbanu. They have been implicated out of suspicion. No, there is no direct evidence connecting them with the alleged crime. Investigation is complete. There is no chance of abscondence. Accordingly, we are inclined to grant anticipatory. Next.
But I'm for the petitioner, my lord. It is alleged that, my lord, out of family dispute and it is alleged that out of family dispute and distribution of money one Toto was rammed over the de facto complaint, resulted in injury. 2 persons have been granted anticipatory bail who were also named in FIR, but mine is rejected.
This petitioner is the nephew. Who hit the?
All right, we have considered the materials on record. Petitioner drove the Toto, which ran over the victim, resulting in grievous injury. He does not stand on the same footing with co-accused who have been granted anticipatory bail. Accordingly, prayer for anticipatory bail is rejected. Other matters will do at 2.
My lord, in which Mr. Patwale had appeared, my lord. My lord, I had spoken, my lord, to the learned public prosecutor also, but he had indicated 13th of February. My lord, 13th of February, there is some difficulties, my lord. Either 6th of February, my lord, subject to your lordship's kind sanction, or 20th of February, my lord. My lord, the learned public prosecutor has given me the consent that either of the dates is fine with him.
20th of February.
20th of February, item number 2.
Oh, good.
My lord, 51, there is victim lady.
Inform.
My lord, already served.
Judge, inform 1 week.
Okay.
Next. Next.
I am for the petitioner, my lord. I have served.
Victim suffered suffered fatal injuries and died. In view of the gravity of offense and purpose involvement of the petitioner therein, we are not inclined to grant bail. Next.
Okay, my lord, I appear for the petitioner. My lord, though initially the case started under section 498A, 376, 307, 406, 506, 34. Subsequently, my lord, against this accused, charge sheet was made under section 498A, 307, 406, 506, 34 of IPC, Kotwali PS, my lord. My lord, matrimonial dispute, marriage took place. My lord, thereafter, subsequently, my lord, the cases has been registered. 2 lady accused, 1 senior citizen, and 1, my lord, in-laws. My lord, initially, my lord, bail has been granted to the one of the accused husband.
Husband one of 376.
Huh?
Against the husband 370.
Yes, my lord. And
Marriage took place on 9/5/2024, and my lord, the FIR was lodged on 25/2024 within 11 days. There was an allegation of pressing pillow, by which my lord, they tried to kill the victim.
no allegation of 376 against these accused.
Injury report
And my lord,
page 106.
the de facto complainant's family is an influential person, local councillor of ruling dispensation. Both were advocates. We were not getting advocates in Nodia court. Pursuant to the intervention of this honorable court, my lord, I have placed the order. We got bail, and thereafter we got, my lord, advocates in the Nodia court. 2 ladies, 1 senior citizen.
Petitioner contends they are the in-laws of the victim lady. Husband has been granted anticipatory bail.
Bail. I placed the order.
A regular allegation of rape is not leveled against them. Under such circumstances, we are inclined to grant anticipatory bail.
Rape.
Next.
GPC came for the petitioner.
Not today.
My lord, physical assault on the dispute of demolition of drain, my lord. And my lord, petition number 1 granted anticipatory.
Case study is there. Not today. Call the bail application.
রিপোর্টটা দিয়ে দাও
Sure. Yes.
I'm for the petitioner. On parity, my lord, I'm praying for bail, my lord. Can you see page 9 of my application?
Similarly placed, the trial would conclude within 3 months, my lord. This is the report that we have.
Report is placed on record.
The prosecution intends to complete the trial in course of 3 months, my lord.
Petitioner is in custody for
1 year, 4 months.
1 year, 4 months. Co-accused have been granted bail. Learned APP submit trial would be concluded in 3 months. However, keeping in mind the aforesaid, we have considered the materials on record. Though it is bail was granted to co-accused on the ground of delay, petitioner is in custody for a considerable period. There is no, though it is assured that trial shall be concluded in 3 months, comma, it is common knowledge that such assurances are often belied due to circumstances, for which the petitioner is not responsible. Accordingly, we are of the opinion petitioner is entitled to bail on the ground of delay. Bail granted on ground of delay is not bail prayer on the ground of delay is not fettered by restrictions under 37 of NDPS Act. Allowed.
Report be kept to the record.
Next.
I'm for the petitioner.
I have not brought the CD or the brief, my lord.
How many days?
1 year, 4 months, my lord. Charge has not been filed.
Petitioner is in custody for 1 year, 4 months. Trial has not commenced. He prays for bail on the ground of delay. Learned lawyer for the state opposes the prayer. We have considered the materials on record. Though it is alleged 400 liters of pencil syrup was recovered from a vehicle, comma, bail is prayed on the ground of delay in trial. Petitioner is in custody for a considerable period. Charge is yet to be framed. Under such circumstances, petitioner has made out a case for bail on the ground of delay in trial. Bail prayer on the ground of delay is not restricted by fetters under section 37 of NDPS Act. Allowed. Next.
I'm for the petitioner. I'm claiming parity, page 6. This is a lordship order.
Claiming parity but this petitioner's bail was earlier turned down in the month of June, where 1 year timeline was given. That 1 year is not over yet.
All right. Petitioner is in custody for
2 years, 2 months.
2 years, 2 months. He renews his co-accused have been enlarged on bail. He renews his prayer for bail. Learned lawyer for the state submit. Trial court was requested to conclude the trial within 1 year, which has not expired. We have considered the materials on record. A petitioner is in custody for more than 2 years. Co-accused have been enlarged on bail on the ground of delay in trial, full stop. Though direction was given to the trial court to conclude trial within, while rejecting prayer for bail of, where is that order?
Page 9.
Though while rejecting the bail prayer of the petitioner in June 2024, trial court was requested to conclude the trial within 1 year. However, there is hardly any progress in the trial. In view of the aforesaid facts, and as co-accused have been enlarged on bail, we are inclined to enlarge the petitioner on bail on the ground of delay in trial. Allowed. हाँ दिए दिए.
I'm for the
My lord,
petitioner.
for the NCB, my lord, I'm praying for not today, my lord. The
Kindly see
CD is
page
not,
10, my lord, parity.
my lord, the
Parity.
CD is not there today. my
All
lord.
right.
Kindly praying for not today, my lord. I'm being
Yes.
led by learned senior counsel, my lord.
Very-
Himanshu De, my lord.
Petitioner is in custody for
More 2 years, my lord.
more than 2 years. On the score of delay, co-accused Nitish Kumar was enlarged on bail. Petitioner stands on same footing and is entitled to similar relief. Allowed. Next.
Yes, I am for the petition. Yes, I am claiming parity co-accused has been granted.
Towards the order.
Page 7 by the Honorable Apex Court.
Apex Court. Petitioner is in custody for
1 year, 4 months.
1 year, 4 months. Co-accused have been enlarged on bail by this court as well as the Apex Court. Petitioner stands on the same footing and is entitled to similar relief. Allowed.
NDPS, sir?
NDPS.
Whether recovery.
All.
Same.
4%.
All recovered.
All.
Co-accused has been released. Supreme Court allowed.
Next the FIR.
But I'm for the petitioner, my lord. I'm claiming parity. Page 52 is the order passed by your lordship. Initially interim bail, thereafter, my lord, confirmed. Page 55, I am in custody for more than 1 year. This man has been granted bail within 6 months of custody. Both of them, my lord, allegation is that they are conspirator. Thereafter, page 55, my lord, it has been confirmed. No adverse report came.
All right. Sanjit Singh alias Appu Singh.
Not too well prepared, but the difference between him from the present petitioner at his instance, the 2 motorbikes which were used at the time of commission of offence, in which the 3 riders had and then shot at the victim, has been recovered. There are CDRs, continuous calls between the other co-accused and the present petitioner, which I do not find in respect of other
My
materials.
lord, 3 other persons.
All right.
My lord, 3 other persons also granted bail from the, they are also standing on similar footing.
Not today. State shall submit report with regard to involvement of the petitioner vis-a-vis co-accused who are on bail.
My lord, I have annexed the charge sheet also where, my lord, specified everything categorically, my lord.
Next.
My lord, I am for the petitioner. My lord, I am praying for parity. My lord, at page 24, the one of the co-accused had been granted bail from the Apex Court. Thereafter, my lord, 2 of the co-accused had been granted interim bail from my lord. My lord, I am praying for these are 2 orders, my lord.
I'll check with these 2 orders in that event. এই দুটো আমার কাছে copy নাও।
ওনাদের একটা কপি দাও না।
Because they were granted bail by the apex court on the ground they had no antecedents. So far as this petitioner is concerned, he has antecedents, my lord.
What antecedents here?
My lord, pardon.
And
Your lordship and
My lord. এটা বলেন।
Mohammed Ali is same financial.
Rahmat Ghazi.
Rahmat Ghaz.
He was present at the spot.
He was present at the spot.
And Shoiful were not present. Shoiful was present.
my lord, Shoiful was also present. Shoiful had been granted bail from the apex. Petition on
What is the role ascribed to the appellant? To Shoiful? You submit not to. Next.
কপিগুলো পরের দিন গিয়ে দেখবো না না ওটাই
Well, I'm for the petition.
For the state, then the
Hmm.
the case right.
Circumstantial evidence, malad nothing against me. Principal is in custody. Malad I am the malad nephew of the principal. Only in 161 statement it says that I was standing with the principal at that evening in a place. That is a single statement. Other than that, there is nothing in the scene.
You had illicit relation.
No, malad. That is the principal.
Okay, not today. Next.
Three 307 Bishal Mahato my lord fired shot at the victim. Co-accused annexure page 10 has been granted bail by your lordships. I am Shubhodip.
We have considered the materials on record. Petitioner is in custody for
But 212 days.
120 days. He is not the principal accused. Co-accused has been enlarged on bail. Accordingly, we are inclined to extend grant bail to the petitioner.
Great.
my lord, I am for the petitioner same as 8, but custody is different.
8 though.
8, but custody
We are keeping it not today. 8 and 12, let it be dealt with by the regular cost. Next.
My lord, for the petitioner, my lord, I am claiming parity. My lord, page 12 is the order passed by your lordship's order. My lord, Appu Mukherjee and this petitioner's pair were turned down. Thereafter, my lord, page 38, Appu Mukherjee has been granted bail. I am in custody for more than 3 years, 6 months. Now, my lord, kindly see page 38 and my lord, page 12. Not the principal accused. Exactly standing on similar footing, my lord, with Appu Mukherjee, alias Babu Sonam.
Where is the order?
My lord, page 12 your lordship's rejection, and my lord, page 38 is the order granting bail to Appu Mukherjee. My lord. 12 and 38, my lord.
Appu Dev has been granted bail.
Appu Mukherjee, alias
Wanted,
Babu.
give a report. Give a report. Huh? State shall CBI shall submit report whether petitioner stands on the same footing with co-accused who have been enlarged on bail by the apex court. All right. When do you file? 1 week?
1 week.
1 week. Next.
Appealing for the petition, your lordship, praying for bail on parity, page number 24, one bail order of Tapos Maji. Case of oral negligence, your lordship. Now Tapos Maji kindly sees the bail order at paragraph number 3, implicated, but the Tapos Maji was also implicated. All the co-accused persons are on bail. I have annexed all the order. Page number 24, your lordship, the specific person I am claiming parity with, Tapos Maji. Order dated 27th March 2024. 2024.
All right.
My lord, I differ, my lord. My lord, the Tapushmaji gave blow on his leg, my lord, but this petitioner gave the vital blow on his head, my lord. For that reason, my lord, the petitioner died. My lord, kindly see, my lord, the evidence.
Evidence,
my
your
lord,
lordship.
the same
Evidence.
My lord, PW 1, my lord, page 2, my lord. I have underlined, my lord. PW 1, Nomita Roy, my lord, who the wife of the disabled who took him to the hospital, my lord. On the way, he stated that Damodar like hit on his head with a wooden.
We have considered the materials on record. A petitioner is in custody for more than 2 years.
3 years, your lordship. 3
More
years, 2
than
months.
3 years. He submit co-accused have been granted bail. Vulnerable witness have been examined. He prays for bail. Learned lawyer for state submit as per oral dying declaration. Petitioner assaulted the victim on the head, whereas others assaulted on non-vital parts of the body. We have considered the materials on record. Bail was granted to co-accused inter alia on the ground that the credibility of the dying declaration has to be assessed in light of other attending circumstances during trial. All vulnerable witnesses have been examined. Under such circumstances, we are of the opinion petitioner may be released on bail.
Grateful, your lordship.
Next.
Lordship, I am for the petition, Lordship. After 2 years of marriage, due to matrimonial discord, the victim committed suicide by consumed poison. I am before your Lordship is a husband. Charge sheet already submitted.
Palpably wrong, my lord. Within 4 months of marriage, my lord, she committed suicide. If your lordship kindly sees the affair, there are call recording, there are WhatsApp thread demanding dowry. My lord, I have referred it even in the affair. My lord, I have handed over all documents to the IO.
How long you are in custody?
147 days. Charge sheet already submitted.
I have prayed for once.
Husband,
my lord. And within
Father-in-law and mother-in-law granted bail by your Lordship. At page 10.
lordship kindly sees the affair. I have referred all WhatsApp chats demanding.
Where is the?
And your lordship kindly sees the date of marriage. My lord, photograph.
All right. 4 months we are doing. What WhatsApp says?
And suicide and notes are there. I have given all this to the investigating officer. My lord. I have prayed for a reinvestigation also. My lord. That is pending.
All the mobile phones have been seized, my lord, and that is the same for my forensic, my lord. That is yet to be received.
Only those are available to us. There are many more in the must be in the mobile section. And this is within 4 months of that.
What is see the what you are saying? Petitioner submits that he is in custody for 147 days. There was domestic disputes, and out of depression, victim committed suicide. allegation of demand of dowry is
One suitable statement of the my lord.
all right. Statements will come later on. Read that WhatsApp exchange. Demand of dowry appears is alleged to be false. He prays for co-accused have been enlarged on bail. He prays for bail. Learned lawyer for the state opposes the prayer. Learned lawyer for de facto complainant submits that there was incessant demand of dowry. Due to torture, victim committed suicide. Prayer has been made for further investigation. We have considered the materials on record. Petitioner and the victim fell in love and married. Full stop. Subsequently, it is married. It is subsequently victim committed suicide. It is alleged that the victim was pressurized for dowry. WhatsApp communications have been placed before this court. Some of the communications disclose discord between parties over other reasons, and depression depression of the victim on such score cannot be ruled out. Investigation ruled out. Petitioner is in custody for a petitioner. There is no chance of abscondence of the petitioner. Under co-accused have been enlarged on bail. Under such continuation of further investigation, if any, would not be hampered in the event the petitioner is released on bail. Accordingly, we are inclined to grant bail to the petitioner. Next.
May please.
I am claiming parity. Your lordship kindly turn running phase 7. Who accused Manoj Ravidas and the present
Ravidas on the
present petitioner is also in custody for 1 year, 10 months. And in this case, only Dilip Ravidas has been identified by the 3 witnesses who have been examined till date, excepting Dilip Ravidas.
Who else? Ravidas has been.
Dilip Ravidas is in custody. Earlier rejected, 3 persons bail was turned down by the honorable court. Thereafter, Manoj Ravidas has been granted.
Regular bench. We are moving us. We rejected regular benches granted. Still, then you are coming before us.
Seize your lordship, I am also in 1 year, 10 months. That person who has been granted 1 year, 10 months.
The evidence says that only one identified Manoj.
Manoj.
How many people identified you?
No, till date, nobody. Your lordship, can you seize? Till date,
They have not annexed all 3, my lord. Only 2 evidence has been annexed, my lord. We have to take instruction, my lord.
All the 3 evidence, where are the 3 evidence? State shall submit report whether petitioner stands on same footing with Manoj Ravidas, who has been enlarged on bail. Next.
18, I am for the petitioner, my lord. It is a case under section 307. Petitioner is in custody for 40 days.
Petitioner submits that
there are
victim did not
injuries,
have
my lord, previous
intention to commit murder. He is in custody for 40 days. He pays for bail. And a lawyer for the state opposes the bail prayer. Nature of injury.
all previous injuries are there.
We have considered the materials on record. Whether injuries are life-threatening may be assessed at the appropriate stage of the proceeding. Petitioner is in custody for 40 days. Further detention for progress. Charge sheet filed.
Not yet.
Progress of investigation is not necessary and they may be granted bail. Allowed. Next.
But I'm claiming
লিখে দাও।
parity with Ontu Mondol, page 11, and Bijoy Sarkar, page 30.
Parity.
Lordship, this is the statement of the mother. She is the complainant, mother of the deceased, your lordship. She has seen after hearing the gunshot sound, she went
Who
to
is
spot.
the
Rajashial fired.
We have
Rajashial fired.
all right. Petitioner is not the principal accused. Co-accused similarly circumstanced with the petitioner have been granted bail. Petitioner is in custody for
300 days.
300 days. Accordingly, we are inclined to enlarge the petitioner on bail. Allowed. Okay.
307, charge sheet submitted. I am in custody for 120 days. Charge sheet submitted. 307.
Charge sheet submitted. We have considered materials on record.
16 days.
Whether
injuries,
investigation is complete, whether injuries are life-threatening may be assessed at the appropriate stage of the proceeding.
And as per the
Petitioner is in custody for
120 days.
120 days. Accordingly, we are inclined to grant bail. চলো হয়ে গেল ওদের কাজ শেষ ওদের কাজ শেষ So, nobody appears for the petitioner. Adjourn 4 weeks. Same. Same.
Well, 60, I'm appearing on behalf of the petitioner. This case is under section 420 and 406, my lord. The petitioner is a private tutor, my lord. The petitioner was induced, my lord, to the tune of rupees 2,27,000, my lord, in lieu of a flat by the private opposite parties, my lord. My lord, thereafter, my lord, we instituted this case, my lord. The petitioner was granted anticipatory bail, my lord. But they were granted bail on the condition, my lord, that they will pay the amount, my lord.
That's a wrong condition.
My lord, they have, my lord,
That's
while
a wrong
their bail
condition.
anticipatory bail application was being considered, my lord, they had paid a amount of 50,000, my lord.
Wrong condition. Petitioner has approached this court
But they have
on
to,
the
my lord,
ground that opposite party number, opposite party accused
my lord, may I?
has not refunded the sum, the sum of money
My lord, may I,
which
my lord?
was handed over to them in respect of a building,
A flat, my lord.
in respect of a sale agreement.
But may I
Are
submit,
of
my
the
lord?
opinion neither neither criminal investigation. We are of the opinion criminal investigation cannot be utilized to recover dues. Any direction for payment of outstanding dues cannot be a condition to grant pre-arrest bail. Accordingly, we are of the
My lord, may I,
opinion
my
no
lord? At
case,
present, my lord, talks of settlement is going on, my
no
lord.
case for interference is made out. Application is dismissed. For cancellation is made out. Application is dismissed. Next.
I'm grateful. Grateful, my lord.
Well, this is my affidavit in reply.
I'm filing not the opposition. Copy, sir.
Why cancellation? Why cancellation?
Well, we have prayed for cancellation on 2 counts. First is that when a person has submitted to the jurisdiction of the learned magistrate and has escaped therefrom without obtaining the order of bail, whether he is entitled to an order of 438 thereafter.
That is the case.
The second is that initially he had prayed for anticipatory bail, that was not pressed. Thereafter, a second application was filed.
That may be filed, but if he has appeared and before the magistrate,
that your lordship will find at page 17. I'm sorry, page 17. Yes, page 17.
Let us see.
Record is put up today by court's order. Petition filed on behalf of accused numbers 1 to 6 and prays for bail. Earlier, she has submitted under this. The accused persons are not found on call. The surrender and bail petitions have been not pressed.
My God.
Issue warrant of arrest against the accused.
And thereafter anticipatory bail.
Thereafter anticipatory bail.
Mr. Ahmed, you surrender before jurisdictional magistrate and
have got bail.
I've surrendered and I've taken bail.
On the basis of
pursuant to this order cannot survive.
The order of
This order cannot survive. No person will be permitted to take out an anticipatory bail after this conduct. If you surrender, you have to be taken into. You are taken into custody. You have escaped from the custody of the court.
The complainant and petitioner is the ex-public prosecutor of the Lord Alipur Police Court.
He may
on
be
that
whoever.
date, Lord, we are manhandled. Lord, we are forced to leave the court. Lord, that was the reason, Lord, we had.
Any complaint was lodged on that day?
Lord, on that date, Lord.
Any complaint that you were manhandled?
Lord,
Mr. Ahmed, all these stories.
We have lodged, Lord, you have intimated the Chief Justice, Lord.
Very good. You have intimated the Chief Justice.
And there are, Lord, this has a, Lord, checkered history, Lord. There are few other facts, Lord. This particular, the bail cancellation, Lord, against whom the cancellation is prayed, Lord, she has challenged the proceedings, Lord, your Lordship, Lord, passed an order of stay of the proceedings. Lord, that order, Lord.
Proceedings are stayed.
Yes.
All right.
Even, Lord,
proceedings have been stayed.
We have not been served with any copy.
Motion stage, Lord,
When?
admitted. Lord, this was on, Lord, 4/10/2024.
So place on record that.
Lord,
At
by your
Danpur,
Lordship.
Mr. Ganguly, senior advocate, contends
Lord, I have annexed
that the order granting pre-arrest bail is wholly without jurisdiction.
Well, it's only a stay of the order. Kindly cease. Operation of the order, the proclamation order.
Lord, there are few things. That's the reason, Lord, I'm saying, Lord.
It was only a stay of the order.
Lord, quashing application filed by few other accused person, few quashed, few have been challenged before the Supreme Court. The Supreme Court has, Lord, admitted the SLP. And I've given in the opposition.
You have filed all these documents in the reply opposition?
Lord, rest document, not this one. But this has been after, Lord, affirmation, this has been.
To file all this.
I'll file a supplementary.
He submits that petitioner, opposite party number 2 had appeared before the jurisdictional magistrate and thereafter absconded. Warrant of arrest was issued. In this backdrop, prayer for anticipatory bail was not maintainable. Mr. Ahmed contends that the warrant and proclamation contents that the proceedings have been assailed before this court. Order issuing proclamation has been stayed.
Lord, before that, Lord, the Honored Sessions has also stayed the proceedings. That stay order, Lord, I have annexed.
Proceedings of this court has been stayed, full stop. Petitioner has submits petitioner has assailed the proceedings in CRR so and so, full stop. In light of the aforesaid submission, opposite party number 2 is given liberty to file supplementary opposition, placing on record additional documents. Adjourn 4 weeks.
I'll give the list of dates and explain every situation.
Next.
Obliged.
আরে হ্যাঁ হ্যাঁ সেই তো দেখছি
Without is patently illegal.
Reply file for
Next.
আরে ভাই
reply has not been submitted to us also.
we have
Dudewala?
আপনি আছেন no my lord, he is not the advocate. Difficulty is
Now he has become counsel.
Why isn't he there?
not there.
Who is advocate only?
One Shubhodip.
You have become counsel who is running office. Huh?
I'm here for the last 10 years.
Others office who is running?
But he's only running. I am
He is running. You have
He has run away.
taken him.
I'm under the umbrella of
Umbrella of ऑफिस चला रहा है और लड़का सीनियर एडवोकेट Next matter.
I'm appearing for the opposite party number 2.
Madam, Mr. Ashwin Kumar Raut is
4
appearing
weeks. 4 weeks on the prayer of petitioner.
My lord, Mr. Ashwin Kumar
4
Raut is
weeks.
appearing for the
Produce what? Produce.
petitioner, my lord.
Tenant has filed a case also
Against the landlord.
My lord, he couldn't come today, my lord. I'm praying for not today. My lord, I'm
After
praying
4
for
weeks.
after 2 weeks. I'm good.
Next.
My lord, I'm praying for not today, my lord. I'm for the petitioner, my lord. I'm praying for not today, my lord.
63 not today হলো 6-2 হলো
64.
ও সব 6
Great.
নেক্সট একবার ডাকছে আমার
Yes, Your Lordship. I'm for the petitioner, Your Lordship. Your Lordship, kindly, I'm handing over one list of date and events, Your Lordship. Affidavits were exchanged.
Accused is not there. Petitioner present, nobody appears for private opposite party accused. Adjourn 4 weeks.
Your Lordship, our direction may be given to the state to produce this CD along with the progress report because, Your Lordship,
Diary is there.
Yeah.
Trial is going on.
No, Your Lordship.
Why?
Because
it was reinvestigated, my lord.
All
Thereafter,
right.
my lord, charge sheet submitted.
Supplementary charge sheet submitted.
Yes.
The supplementary
Your Lordship, we don't get that instruction, Your Lordship. Till date.
supplementary what? Nothing is there.
Kindly allow me for 2 minutes, Your Lordship. Petitioner's sons was found hanging in front of the.
All right, hanging 4 weeks.
Thereafter, it was assumed
4 weeks. Murder or suicide. Go on. Next. Next matter. 66.
Well, the petitioner complainant's mother's signature was forged on a document which is now being used by the accused to claim some property.
My lord, I am for the
But it has been incorrectly recorded as affidavit of service filed. Reply was filed on the last occasion.
Who is for accused?
My lord, I am for the accused.
All right.
I am for the accused, my lord.
So why cancellation?
My lord, the interesting thing is that the accused says that I am in possession of the forged document, but I will not hand it over to the IO.
No, my lord, there is a pre-instituted civil suit, my lord, filed by the accused as a plaintiff.
Yes.
And the complainant is and the petitioner is contesting this suit. And my lord, while the accused moved an injunction application, he used this document as a licensee and as a permission as a licensee. His mother allows me to use.
One thing, please clarify this. The document, has it been original, has been filed before the trial court? It has not been tendered.
It has not been tendered, my lord, but at the time of injunction, we have submitted this.
Correct. You have submitted in Firisti, taken it back.
Yes, my lord.
So now you hand it over to the police for investigation purposes. Okay.
My lord, in that event, my lord, they appeared in this matter, my lord, and they will, while the document will be seized, my lord, they will move the injunction application, and my lord, injunction will be vacated. Only this document is my only document.
Vacated. You obtain a certified a copy, either a certified copy of the document if it's a registered document. If it is
No, my
not
lord, it's an unregistered document.
registered document, then you have a notarized copy of the document for the purpose of production during injunction hearing. All right.
Yes, my lord. In that event, I will produce this.
Petitioner and opposite party number 2 undertakes to supply original copy of the alleged forged agreement to police for investigation. It shall be open to the opposite party number 2 to obtain a notarized copy as secondary evidence for secondary evidence in his possession. With this clarification, application is disposed.
One more thing, my lord, but regarding my learned friend title, let him produce those documents.
That will be later on. Needless to mention, issue regarding it is clarified that the investigation would be restricted to the validity of the document, would be restricted to the validity to the fact whether the document is forged or not. Right title or interest in the property would not would be decided by the appropriate civil forum. As in light of the undertaking given by the petitioner, we are of the opinion the order granting anticipatory bail to him need not be cancelled. With this,
Now the accused is, my lord, in regular bail.
with the anticipatory bail granted, order of bail granted to the opposite party accused need not be cancelled. With this observation, application disposed of.
My lord, the document would be handed over to the IO within a specific period.
Next.
Earlier, a report was called for regarding the post-bail conduct of the opposite party.
Report be filed adjourned 6 weeks. Next.
I'm for the statement.
Lordship, I'm for the petitioner. Lordship, I'm praying not today, Lordship. Kindly, Lordship.
6 weeks. Next.
69, I am praying for not today on behalf of Miss Jui Dotto Chakraborty. Her mother-in-law is
6 weeks.
Lord, I'm for the opposite party, my lord,
Next.
led by petition.
At 70, I am appearing on behalf of CBI.
CBI dismissed.
My lord, I'm praying for some time, my lord. Praying for
6 weeks on prayer of CBI adjourned 6 weeks. Petitioner CBI asked for time 6 weeks.
Earlier twice this application was taken and this was cancellation of cancellation of bail, my lord, application. It is presently under the heading cancellation of anticipatory bail, my lord.
So
That is the
no anticipatory bail was granted.
no, my lord, it was bail.
Bail released due to lack of determination.
That is
Yes. Other matters tomorrow.